Hello. Our lesson for today, we're looking at the Fourth Amendment, and the goal would be to have a general understanding of what the Fourth Amendment is and the court cases that fall under the Fourth Amendment, which is search and seizure. If you remember from discussions on the Revolution, used to have something called the writs of assistance. Under the writs of assistance, a British official could search your person, place, home, warehouse, business, ship, warehouse, carriage. Of course, they didn't have cars back then. So any of that could be searched with a document signed by government officials, judges, or whatever. But really, just search anything, everywhere, anytime. Just go for it. It also, I don't know if we talked about this before, but could also allow the official to get anyone near to assist in the operation of servicing the warrants against you. Just common people, other officials. Today, it's usually done by police officers directly, but back then they could grab anybody to help conduct the search warrant. All right, so I'm going to read a court case under the Fourth Amendment. Um, that put in the Bill of Rights, Amendment 4. All right, so this case is called Terry versus Ohio. This is Cleveland, Ohio. A police detective in plain clothes was assigned to patrol an area looking for shoplifters or pickpockets. On the day, he saw two men on the corner talking with each other. One man left the other and walked past several stores, looking carefully in the store window. The second man did the same thing. Each man repeated this walk 5 or 6 times. A third man joined the two and spoke with them briefly. The detective feared that the men wanted to rob a store and that they might have guns. Since they might have guns, the detective also had reason to fear for his own safety. He approached the men and asked them their names. They mumbled something. The detective spun one man around and frisked him, patted the outside of his clothing. He felt a gun in the left inside breast pocket of an overcoat. He removed the overcoat and found the gun. The detective frisked the second man and found a gun in the outer pocket of his overcoat. No weapon was found on the third man. All three men were taken into police custody. The two men who had the guns were arrested and formally charged with carrying concealed weapons without a license, which is a violation of state law in Ohio. So the gist of the case for the men that uh, had charges against them was that they weren't actually in the act of committing a crime. Even though you could say they had guns, you able to read their mind that they were going to rob that store because they never actually did it. All right, so this heads to the Supreme Court. All right, in the Supreme Court, having to decide on that they are violating the state law that prohibits people from carrying concealed weapons without a license. Um, the first issue in the case is whether or not the police had the right to stop a person on less than probable cause or reasonable cause that the person had committed, was committing, or about to commit a crime. The second issue is whether or not the police had the right to frisk a person to see if he or she had a weapon. The Supreme Court ruled that the stop and frisk were proper. It declined to suppress the guns as evidence in the trial. The Supreme Court ruled that a police officer stopped someone on reasonable suspicion of criminal activity, and at the same time, the officer had a reasonable fear for his or her safety. The officer had the right to frisk the suspect for weapons. Okay, so um, I guess part of police work is intuition that you think something is happening. So, do you wait for it to actually take place to take action, or um, do you stop someone like it looks like that person's going to jaywalk? Oh my gosh. So you stop the police car, get out. Here's the ticket for jaywalking. They're like, I didn't jaywalk yet. And they're like, the police officer, like, I knew you were going to jaywalk, so here's your ticket. Probably not going to fly. But when we talk about armed robbery and things with weapons and people's lives in danger, um, and robbing the bank or whatever, jewelry stores, etc., a little more serious. So it appears that this police officer is kind of reading their minds, but they also are doing some things that make it seem suspicious. And when a police officer asks, "Who are you? What are you doing?" and you're like not sure who you are, and you're giving kind of mumbling answers, and you're not like, "Oh, my name's Bob Smith." It shouldn't be hard for you to recall your name and what you're doing. So all these things kind of fell in favor of the police, and the conviction is held that these men, there was reasonable cause, and the search was legal under um, Terry versus Ohio. All right, so I'll send you a link for that court case. You can listen to the arguments there. All right, so um, the next one is Cybron versus New York. All right, so this is a little bit different situation. Weapons are not involved. I just have to find it in my textbook here. Lots of cases. And I guess what we're looking for you to do is when you hear these court cases and processing it, that you are kind of like, well, if I was on a jury or if I was on Supreme Court, how would I find, is it reasonable to assume that there might be a crime going on, or should people just be allowed to do whatever they're doing and then take action once the crime takes place? I'll mention a movie here that um, Tom Cruise movie, probably a dozen years ago, called The Minority Report. And in that movie, the government was so in tune to what people were doing. Um, we think about Google Home and Alexa, and back then the government was so involved in watching and uh, being able to access your information that they could even access your thoughts. And if you thought about a crime before you could do it, the government would come in and arrest you because you were thinking about the crime. So they kind of were able to prevent a murder or something because they knew that the person was thinking about it. And then you would be found guilty and possibly executed because you were thinking about committing this crime. So that's kind of a futuristic view on how government could end up and what technology can do in the future, say a 100 years or 1,000 years from now. Hopefully, it doesn't get to be like that. But 10 years ago, during that movie, you didn't even think about stuff like that we have now, like Google Home. And um, is the government listening to you, taking your data and listening to what you say? I don't really care. If they want to listen to my boring life and what we say at the dinner table, more luck to them. Nothing that exciting happening in my home. I apologize if I sneeze. All right, so next case, Cybron versus New York. One day, a police officer was patrolling his beat in New York City. Between 4 p.m. and midnight, the officer saw a man speak with 6 or 8 persons. The officer knew that the 6 or 8 persons were drug addicts. and the officer did not hear the conversations. Moreover, the officer did not see the man hand anything to the addicts or take anything from them. In the late evening, the officer entered a restaurant. The officer saw the man speaking with three other persons known as drug addicts. Again, the officer did not hear the conversations or see anything handed to the addicts or taken from them. The police officer then went up. He had been watching and said, "You know what I'm after." At the same time, he put his hand into the man's pocket and pulled out several envelopes. They turned out to have cocaine in them. The man was arrested for possession of cocaine, a violation of state law. The issue is whether the officer had the right to stop and search the man. Uh, the Supreme Court ruled in favor of the man, stating that the police had no right to search him. So here you kind of have the same police officer work. One sees somebody possibly ready to rob a jewelry store, and here you have a police officer seeing that this is a possible drug deal happening. Um, Now, the Supreme Court in this case rules that it is different, that you have something that is happening, but you don't see the evidence. In one situation, possible death or serious harm can come to others or the police officer himself. In Cyber versus New York, the officer's not in fear. The people in the restaurant, the public are not in danger, immediate danger. So there's no reason for immediate action. And what the officer thinks is happening, or he turns out to be right, but he does not have enough probable cause or evidence to actually grab the person and arrest him. So, similar cases as far as what the police are thinking is happening, but different outcomes for what the Supreme Court actually decides. But I guess the danger factor for the first case in Ohio versus the lack of danger in the second case is predominantly the issue at hand. But the rights of the people to be searched and seized, you or your uh, possessions, still the same issue. All right. So, um, uh, the violation of the second one, Cyber versus New York, is there's a law against possession of cocaine. Did the officer have the right to search the man? The court ruled that they ruled that the drugs seized from Cybern had to be suppressed. Without the drug evidence, you can't have a crime about drugs if you don't have evidence of drugs. Uh, they decided that the defendant had done nothing except talk to people. Since he had done nothing to suggest criminal activity, there was insufficient evidence for the officer to make a forcible stop in order to question him. Moreover, there was no indication that the officer feared for his safety. Therefore, the Supreme Court ruled that the drugs seized from the Cybern had to be suppressed and could not be used against him in trial.